The world of conflict resolution, mediation, settlement conferences, it can often sound, well, a little bit technical, a bit dry.
Yeah, dusty corner of the legal world.
Exactly. And you might assume that nothing really revolutionary ever happens there. But if you did, you'd be missing this huge story that's unfolding right now.
Mm-hmm.
Okay, let's unpack this, because the entire landscape of mediation across the U.S. is undergoing this quiet but really powerful shift. It's redefining who is responsible for what and when cases actually settle.
It's so much more than just, tweaking a few rules here and there. It's a systemic realignment.
A realignment, that's a good word for it.
You've got major developments all converging at once from state Supreme Courts, professional bodies like the AFCC, court systems. And when you put it all together, the direction of travel is just unmistakable.
And where's it going?
Mediation is moving away from being this sort of elective alternative and becoming an essential routine and a very highly regulated part of the justice system.
So that means, what, stronger expectations for mediators?
Much stronger expectations for ethics, for competence, and a really sharp focus on safety, on informed consent, and especially on protecting children's needs. The field is basically professionalizing in front of our eyes.
So our mission today is to kind of synthesize all these intersecting changes, give you a roadmap.
That's right. We've pulled out 3 core interlocking trends that are driving this whole transformation. First is what we're calling institutionalization.
Okay.
That's how the courts are basically forcing mediation to happen earlier and more routinely. Second is professionalization, just a radical change in what's expected from mediators.
And the third?
Vulnerability safeguards. How the process itself is adapting to screen for and protect the most vulnerable people in the room.
Let's start with institutionalization then, because this is where state systems are really structurally changing when and how cases get to mediation. It's becoming less alternative and more mainstream.
Exactly. And we've got 2 great examples, North Carolina and New York. Very different approaches, but both really significant.
Okay, so take us through North Carolina first.
Sure. So North Carolina, effective January 6, 2025, has focused on these really meticulous administrative changes. The goal is just to reduce the bureaucratic friction.
Right. So for a mediator or a lawyer, what does that actually look like?
On the surface, it's things like streamlining how mediators get designated. They now have separate forms if the parties choose the mediator versus if the court appoints one. Little things to make the paperwork smoother.
But, digging into this, I found something that seems like way more than just a new form.
Oh, yeah.
It's this one detail. They're getting rid of the requirement for the attorneys to sign the final mediated settlement agreement.
Right. And that is a huge, huge deal.
It feels like it strikes right at the core of who's responsible, right?
It's a complete philosophical shift. Historically, that attorney signature was, it was the safety net. It was the explicit confirmation that a lawyer had reviewed and approved everything.
And now that's gone. So who shoulders that risk?
It shifts squarely onto the mediator and the parties themselves. Now, on the one hand, it does streamline closings. You don't have to chase down signatures from 3 different law firms.
True.
But it places this enormous ethical duty on the mediator. If you have a party who is unrepresented or just vulnerable, the mediator has to be so vigilant that they truly get what they're signing, because that lawyer safety check is just gone.
Wow, that's an impossible tightrope to walk, isn't it? To make sure they understand without giving them legal advice.
It absolutely raises the bar for competence. But this is happening alongside some other changes. For example, they're also clarifying confidentiality.
How so?
Well, the NBA rules are reinforcing that confidentiality is strong, but it's not absolute. They've clarified that a mediator can be forced to disclose information not just by a statute, but also by a rule from a state or even a federal agency.
Oh, that's a subtle but important expansion. So an agency, not just a legislature, could compel a disclosure.
Exactly. And at the same time, you're seeing this strong ethical pushback on the other side. Mediators are being told they can't participate in settlements that try to stop parties from reporting lawyer misconduct.
So no more using mediation as a shield for gag clauses about bar complaints?
Right. The system is trying to be efficient, but not at the cost of its integrity.
Okay, so let's shift over to New York. They're institutionalizing mediation in a totally different way, right? It's about volume and timing.
It's a massive change. They've introduced what they call the Presumptive ADR initiative.
Presumptive, meaning it's the default.
It's automatic. For huge categories of civil cases, personal injury, Commercial disputes, estates, and especially matrimonial cases, the referral to ADR happens right at the beginning of the case.
Not after a year of fighting.
No, this is the most disruptive part. Historically, mediation was a late-stage, Hail Mary pass after everyone had spent a fortune on discovery. New York's policy now puts that referral into the very first court orders.
But I imagine litigators who make their living on discovery and motion practice would just try to sidestep this. How easy is it to opt out?
It's very limited. You can only avoid it for good cause. So, if the issue is something a court can't actually rule on, or if there's a really severe documented power imbalance, you might get out. But for most cases, it's an early mandatory milestone.
What does that do to a law firm's whole business model?
It fundamentally changes the relationship between time and value in a lawsuit. It creates this early pressure point. A litigator can't just file a claim and wait 6 months to think about settlement.
They have to be ready to negotiate from day one.
They have to. It requires early case assessments, early client counseling on strategy. It forces a mindset shift away from procedural warfare toward, collaborative problem solving.
But doesn't this run the risk of just becoming another bureaucratic hoop to jump through, sacrificing quality for speed, especially in smaller cases?
That is the exact risk. And that brings us perfectly to our next big trend, because getting cases in the door early is only half the battle. The other half is making sure the quality, the safety, the fairness of that process is actually high. And that transition from focusing on when cases settle to how well they settle is exactly what the new AFCC 2025 standards are all about. This is the professionalization push.
Okay, here's where it gets really interesting, especially for family law folks. The AFCC model standards, these things raise the bar significantly. Tell us about the core duties.
What's really telling is how they've reorganized them. They've sequenced the duties very deliberately. First, as always, is self-determination.
The party's right to decide.
The party's right to decide. But immediately second, right after that, is informed decision-making. Then comes education. By putting informed decision-making second, they've elevated it. It's not enough anymore for a mediator to say, well, they chose it. Now it's, we made sure they understood what they were choosing.
Okay, hold on. If the parties have the right to choose and the mediator can't give legal advice, how on earth is a mediator supposed to ensure informed decision-making? Isn't that the same impossible tightrope we just talked about?
It is the single biggest challenge in modern mediation. But it's about the distinction. Informed decision-making means the mediator has to actively support the party's comprehension of their options, the risks, legal, financial, practical, and the consequences.
So give me an analogy.
Think about buying a complex financial product. The seller can't tell you what to buy, that's advice. But they have a duty to thoroughly explain the features, the risks, the fees of all the options. That's informed decision-making. The mediator is in that role now.
That demands a much higher level of skill. The mediator has to be more of a process guide, not just a passive facilitator.
Precisely. And that leads directly into the new standards on safety. The AFCC standards devote a huge, really unprecedented amount of attention to screening for barriers. Barriers to capacity, to safety, to voluntariness.
What kind of specific barriers are they talking about?
Well, they go way beyond the old-school domestic violence checklist. The standards now specifically name things like coercive control, substance use, mental health capacity, even technology access and cultural factors.
And what's the key mandate for the mediator?
The duty isn't just to screen for a label, like abuse victim. It's to focus on specific behaviors and safety indicators, and then design the process around those realities.
Can you give us a concrete example of what that looks like in practice?
Sure. Let's say the screening reveals a pattern of coercive control. One party is using tech to constantly monitor the other. The mediator must adapt the process. That could mean mandatory shuttle mediation, using separate virtual rooms, or requiring a support person to be present.
So it's not one size fits all.
Not at all. And the new standards also have a much more detailed termination clause. It lists expanded reasons to just end the mediation if safety or capacity or just basic fairness are compromised. It protects everyone.
And speaking of tech, the AFCC standards are finally wrestling with online mediation, which is everywhere now.
Yeah, this is their first real sustained guidance on online dispute resolution, or ODR. It covers the practical stuff, which platform to use, privacy. But the real focus is on making sure the online format doesn't make power imbalances worse.
How could it make them worse?
Well, think about the digital divide. One person might have great high-speed internet in a quiet office. The other is on a glitchy phone connection in a crowded apartment. The mediator now has an explicit duty to manage that, to make sure technology doesn't inherently favor the more resourced party.
That's a big deal. It normalizes online practice, but with guardrails.
With explicit safeguards, exactly.
And what about the biggest point of contention in family law? The kids.
Yeah.
How do you bring the child's voice into the room without putting them in the middle?
The new standards really push programs toward formal, evidence-based models. They codify two main approaches. First, child-inclusive meetings, which are done very carefully with a trained child consultant.
Okay.
And second, child-informed approaches, where the mediator uses specific techniques to make sure the kid's needs are front and center, but without the children ever being in the room. This makes it much harder for mediators to just, casually and unskillfully involve kids.
It sounds like all of these new requirements, safety screening, tech management, child voice clarity, it all just boils down to a massively higher expectation of competence.
They absolutely do. The AFCC standards explicitly say mediators need ongoing education, they need supervision or mentoring, and they need specialized training for complex issues like abuse and child maltreatment. It's no longer optional, it's the baseline.
So what does this all mean for you, the person using the system or observing these changes?
If we pull back and synthesize these trends, the picture's pretty clear. You've got the system integration from places like North Carolina and New York that's shaping the when and how cases get to mediation.
Right.
And then you have the competency uplift and the vulnerability safeguards from the AFCC standards. And that's shaping the how well mediation is actually done. It's all interlocking.
So for practitioners, for mediators, the message is pretty clear. Adapt or get left behind.
Absolutely. Mediators have to be proactive. Invest in training cultural competence, abuse dynamics, ODR. They have to align their whole practice with these new rules. And the ones who do that, they're going to be in high demand.
And for the people actually going through a divorce or a civil dispute, what's the end result for them?
Well, they're going to encounter mediation earlier and more often, which hopefully means faster, cheaper resolution. But the crucial part is that they'll benefit from much stronger safeguards than ever before. The system is pushing for outcomes that are truly informed, truly voluntary, and sensitive to things like safety and the needs of children.
So higher quality, even with higher volume.
That's the goal.
It really is a profound shift. We're watching mediation move from being an elective service to an integral, highly regulated part of our justice system.
Indeed. And this whole realignment, especially in states like New York with presumptive referral, it naturally encourages data. They're collecting data to see, is this working? Is it efficient? Is it fair?
Which, of course, leads us to our final provocative thought for you to chew on.
Right. If the data comes back and proves that this early presumptive mediation is really effective, that it resolves cases efficiently and fairly, what's the next evolution? Will we see mandatory pre-filing mediation for certain types of cases?
Meaning you'd have to try ADR before you could even file a lawsuit.
Exactly. It would entrench mediation not just as a milestone in litigation, but as the required first step in resolving legal conflict in the U.S.
A profound thought on how this quiet revolution could very soon become the required rule. Thank you for joining us on this deep dive.